Yes. So, welcome to the day 7, everyone. Today is the most important discussion. So, until now, I'm sure all of you would have been able to appreciate all the domestic laws like Indian Trust Act, income tax, and how those laws play around with the type of trust that we wish to establish. Plus, we had also learned apart from trust in detail about will, which is also an important succession planning tool. So, with this base, we are through with the domestic part of the succession planning. But what happens is that in most of the cases, when you will be in the practical world, there are going to be situations where cross border angle is going to be important. So, this is the last flavor which we need to add to our succession planning webinar. So, today's discussion is going to be quite important, and we'll be focusing on cross border private trust. Our discussion is going to be divided into two parts for FEMA and international tax, and we'll try and see how things can go about. So the agenda for today is going to be divided into 7 broad headings. First is we will try first 2 points are going to be just an introductory point where the terminology of cross border might be new to a lot of our participants. So to help them understand, we'll first explain what we mean by cross border succession planning, and then when I talk about cross border trust, actually what kind of structure I am talking about. So this will lay the foundation for understanding the cross border aspect of it. Then is an important aspect, because what happens is that once you are into the domestic horizon, it's very easy for you to create an index of what kind of regulatory framework do you have to refer to. But when you are in the cross border situation, I've often seen people getting lost into even developing an index for going about handling cross border private trust and succession planning matters. So this is an important slide where I give you a broad landscape of how the legal framework is for a cross border trust and how you should go about traversing that particular gamut. Then my slides 4 and 5 onwards, we are going to be focusing more on the FEMA part of the story. Now what I realized is that the theory part of FEMA, I'm going to cover it, but it is going to be very difficult for you guys to digest it, because FEMA is a very complex discussion as far as cross-border trust is concerned. So few months back I held a seminar at one of the prestigious forums which was only focused on FEMA implications in cross-border trust, and that discussion itself lasted for about 3.5 to 4 hours. So that is the kind of complexity that comes in when we are discussing about FEMA. So to at least give you a flavor of it, I have tried to develop a simple case study. So we'll see that case study, and I have also kept a flow of thought in as part of that case study. So that might also help you in practically seeing the FEMA regulations. Yeah. After doing that, another important angle in the cross-border setup when we talk about income taxes, the determination of residential status, because it has very important implications. So we'll have a look at that. And finally, a couple of cross-border tax challenges which we most commonly hear about. We'll just briefly discuss about them. So this is going to be how our day and the webinar would look like. So yeah, directly jumping into the first part of what is cross-border succession planning. See, what is succession planning we have discussed at length in our webinar number 1. So I'm not repeating that. Now just bringing in the cross-border angle. So what happens is that in a family, if you are discussing about succession planning, then how does that become a cross-border succession planning is very important for you to understand, okay? Because that completely levels up the game. So these days, I am sure all of you, either in your own family or at least in your friends and peers, you would surely be aware of many families where how the setup is that a couple of family members are here in India, a couple of family members are outside India. So the family geography is divided into multiple countries. And to add on to that, what happens is that these days a lot of people have their assets also in more than one country. Some assets in India, some assets overseas. So even your asset profile is divided into more than one country. Right. So both these things, family members in more than one country and asset profile in more than one country, this is treated as the cross-border dynamics per se. So now for this kind of a family where you have to plan for succession, we call it as cross-border succession planning, because not just because this is not confined only to the border of India, This is cross-border situation where more than one country will be involved, and to traverse the legal landscape of such a succession planning is very important to understand. So this is what we talk about cross-border succession planning, that the family composition and asset profile is scattered across the globe. Yeah. Now coming to what is a cross-border trust. Okay, so we all know the structure of trust. There has to be asset, settler, there has to be estate, which is the trust property and all those things. So in a cross-border setup, how does it play around this? So this is a brief chart that explains that. First, as we had said, that the idea of trust originates in the mind of the settler. So here is the settler. The settler can either be resident or a non-resident. This brings in the cross-border flavor. Then the estate, which is nothing but the trust property, can either have its situs in India or it can be overseas. Once this is true, then the person has two options to settle a trust. One could be to settle a trust as per the Indian regulations, which will be as per the Indian Trust Act 1882, or he has the option to set up trust in an overseas country as per the trust regulations in that particular country. So you will have option either to have an Indian trust or a foreign trust. Once you have sorted with that, then again you will have a choice of whether to make it revocable, irrevocable, discretionary, specific. This is not exactly a cross-border angle, but it will add complications to it. Then you are left with the question of deciding who the trustee has to be, right? So in either case, you can have either a resident person as a trustee or a non-resident person as a trustee. Someone can have a thought that Dhruv, earlier in one of the webinars, you had mentioned that as per explanation to section 60 of Indian Trust Act, a non-resident person cannot be a trustee. Just to recollect, that was true as per Indian Trust Act, but it's a suggestive provision. You can override that by giving an effect into the deed. So it's possible to also have a non-resident trustee. Same goes even for foreign trust. You can either have a resident person as a trustee or a non-resident person as a trustee. And your beneficiaries, they might either be resident or non-resident, and even in foreign trust case, that could be a combination. So there are so many permutations and combinations available. My team just used a simple mathematical formula to arrive at a number that what are the total permutation and combinations possible. So it was a hopping 128 as a number. Was it? This is just for fun sake we have kept this number. I'm not sure of the accuracy of that, but I'm sure that there is going to be lots and lots of options when you are talking about cross-border setup, and each permutation and combination will bring its own set of complications as part of this. So when we talk about cross-border trust, you have to understand that some of the aspects are resident and some of the aspects are non-resident, all part of the same trust. Because say for example, the settler is a non-resident, he has assets overseas, he is settling a foreign trust with non-resident trustee and non-resident beneficiary. If all throughout it's non-resident, then this is not treated as a cross-border situation because you might be part of the same country. Similarly, if resident Indian trust, but trustee is also resident and beneficiary is also resident, then again this is a domestic trust. Cross-border angle is not involved. So there has to be a combination of resident and non-resident angle. With this, now a very important slide. What is the legal landscape for a cross-border trust? Because many a times I have seen people struggling to even design the index. See, I'm not saying that any one professional or me, I would have answer for the entire legal landscape. But what becomes important is when the client approaches us, we have to design an index for them, and then we can tell them that out of this entire index, these areas I'll be able to handle. For other areas, we might have to bring in an external support. That is also absolutely fine because most of the cross-border succession planning assignments would need more than one consultant spread across geography to help the setup in the right way. But many a times people struggle to just design the index. So the next question of whether you can handle it or you would need external help also becomes very vague, because if you need external help, you first need to know the question for which you are seeking the answer. So it becomes very difficult to do that. So this slide will at least help you build a broad index. So when we talk about the legal framework of a cross-border trust, it can broadly be divided into two parts. One is the domestic regulations and one is the cross-border framework. Okay. Here when I'm talking about domestic regulations, it does not necessarily mean India. I'm talking about domestic regulations of every country that is party to the trust structure. So say for example, I am in India, my family is in US, I am settling an Indian trust. So the domestic regulations of India and the domestic regulations of US. All of them form part over here. So here we are just ignoring the cross-border angle. We are considering domestic laws of each of the countries in silos on a standalone basis, which are interacting for the trust structure. Okay. Now, what kind of domestic regulations you have to go through? Because in India, I have already shared the entire list of regulations with you in all the prior, webinars. But when it comes to some other country, how would you even know about the acts those are there? Like, we won't know what is the income tax act of a country like Mauritius or a country like Uganda. It's impossible for us to know the name of the act. So how do you search for that? So here is the list of broad categories of regulations that you have to check for each country. First is going to be for the trust formation, validity and administration. There has to be a trust law in place. So you will have to see the trust law. Then residency and domicile related regulations become extremely important. Importance of that we have already discussed. Then you have to see what are the succession laws of those countries and how is the asset situs determined in each of the country. This becomes the next important law. Then you have to think about the local tax obligations, which could be income tax, wealth tax, estate duty, gift tax, and such kind of regulations which are income tax, kind of an income tax in nature. So that you have to verify. And finally, you have to see the foreign exchange and capital control regulations. These are very important. Like in India, our exchange and capital control regulation is in FEMA. So each country would have its own set of foreign exchange regulations and capital control regulations. This becomes very important. Why? Because when we will discuss about FEMA, you will appreciate that FEMA has such an important role in even establishing the trust, validity or permissibility of the trust. So exchange regulations become very important. So these are the broad gamut. Sorry, I've missed one thing over here. I'll mention that. Next is going to be stamp duty as well. So every country might have its own stamp duty regulations also. So that also one should keep in mind per se while deciding for the domestic regulations. Yeah. So once the domestic regulations of each country in silos is complete, then you have a look at the cross-border framework. Now what happens is that you have decided that there are say 1, 2 or 3 countries put together. Now what happens is you have to then think about that each of these countries domestic regulations is done as part of your indexing. Then you come about that each of these 3 countries will also interact with each other as far as the regulatory things are concerned. So what kind of inter-country regulations have to be selected and looked after? That comes under the cross-border framework between multiple countries. Yeah. So here what kind of regulations you have to refer to? First is the DTAA, which is the double taxation avoidance agreement between 2 countries. This is the most famous and most common regulation which we have to see to remove any double taxation arising on account of certain tax issues. Yeah. Next, very, very important, especially for trust transaction, is exchange of information. See, many a times I've seen clients becoming very savvy or very conservative as far as disclosures are concerned for a trust structure, right? Every country has a certain set of mechanism where distinct details about your trust structure are reported, and then every country shares information with other country. It is called as exchange of information. EEOI stands for automatic exchange of information. There is some information which is automatically exchanged. There is some information which is on pool basis, that the country which requires information places a request to the source country and the source country shares the information. So a lot of information is getting exchanged between countries these days. So recently I had a chance to attend a very important conference where the person who is head of the exchange of information department of CBDT, which is income tax, was one of the speaker, and he told us that India is getting information from more than 50 to 60 countries in an automatic way on a regular basis. That's a huge pool of information. So you have to be very knowledgeable or understand what is the kind of exchange of information that is going to happen between 2 countries, and ensure that you do all the reportings and everything in such a way that it doesn't create friction between any records. So your litigation risk would reduce dramatically. Yeah. Then another very important point is extradition agreements. You have to see this also in a very strong way, because what happens is that one of the purpose of succession planning we had discussed was to ensure ring fencing of the wealth. and that personal liabilities should not be attached over here. So extradition agreements and then asset attachment agreements, these become very important to understand. That, say for example, you are in country 1, you have a trust set up in country B which has wealth either of country B, country A, or some other country beneath that. Now if say some liability comes on you, then what is the kind of agreement the country A has with country B to attach your assets, freeze your assets, or bring or seize your assets in other countries as part of the liability that is arising to you in country A. So your extradition agreements and asset attachment agreements between those countries become very important for you to understand that kind of a ultimate risk. This becomes extremely important where the client is very, very sensitive about ring fencing of the wealth. You have to keep this in mind. I have seen many cases where these kind of laws and agreements were not taken into account, and then it actually defeated the purpose of ring fencing. Perfect. So with that, I think now we'll come to the subject of our day, which is discussion about FEMA regulations. So this is more sort of going to be only an introductory phase, because as I said, it's not possible to do justice to FEMA in such a short time, but we'll try and see the spirit behind the laws. So what are the considerations under FEMA which are important? First is trust not recognized as a person. So like we discussed for Income Tax Act, even under FEMA, trust is not considered as an independent legal personality. In fact, most of the FEMA regulations and FEMA Act don't even use the word trust. Yeah? So if FEMA doesn't even talk about the trust structure, how do you see the regulations apply to this particular structure? So the spirit and principle over here is you have to pierce through the structure. Meaning what? The trust is nothing but a conduit pipe. We have discussed about it. The settler has settled something for the benefit of the beneficiaries, but the things have not yet moved to the beneficiary. It is in limbo, it is in conduit pipe under the supervision of a trustee. Yeah? So you have to pierce through this particular shelter, you have to pierce through this pipe, you have to ignore the structure, is what we talk about in layman terms. And you have to see that had the trust structure not been there are three parties. One is a settler, trustee, and beneficiary. If there would have been no trust structure and see the transaction would have happened directly between them, then what would have been the implication? That is what is called as piercing through. So you pierce through and analyze transactions happening between the key constituents, which is the settler, trustee, and the beneficiary. Right? So you pierce through, forget about the trust structure, and see how the transaction is happening between two persons. Then comes the question is, when the settler is settling the asset, which is the first and biggest, most important test in the trust structure, how do you see this transaction getting classified under FEMA? So settlement is not defined under the term transfer or transaction under FEMA. Okay. So what do you have to see? If I have to see, the settler would have directly transferred this particular asset to the beneficiary and not as part of the trust structure. How would have this happen? So there is a case law of Gujarat High Court, Bhavna Nanavati, and one of the master direction on remittance of assets under FEMA have given an indirect hint to us. So we take these legal references and accordingly hold a view that settlement of assets is deemed to be akin to gift. Okay. So while analyzing the FEMA provisions where there is a settlement happening, you ignore the trust part and then you just directly consider that the settler would have gifted assets to the beneficiary. And what does the gift provisions in this situation talk about under FEMA? That is how you have to give consideration to FEMA and do the analysis. Next, under FEMA considerations, there is an important concept of capital and current account convertibility. See, account convertibility is a very important concept which we all have to appreciate when we are talking about exchange regulations. What it says is that if today certain forex has come into India, on an override basis, based on the whims and fancies of the overseas party, can he withdraw this forex overseas? This is considered to be convertibility. So if your country is 100% account convertible country, so any amount can come into the country for any purposes, and any amount can flow outside the country based on the desires of the person who has sent in. There is absolutely no restriction, limit, or prohibition by the country in place. Obviously, certain provisions like say terrorist funding, money laundering, those laws are separate. But per se on forex convertibility, there is no restriction. So there are many countries in the world where currently we know that it's completely free conversion, and that is why those countries see heavy financial services money coming in, flowing out, and those are like financial services hub of the world. Yeah. Now, why we are talking about capital and current account is because the transaction that you have at hand, it is very important to classify either that as current account transaction or as capital account transaction. Why? Because the spirit of FEMA in this case is going to drive on whether your transaction is going to be permissible or no. So, say for example, your transaction gets classified as a current account transaction. It's a very good situation because current account transaction, the general principle under FEMA is all current account transactions are generally permissible unless specifically restricted. Meaning what? If it's a current account transaction, your mindset should be this is allowed. Then you have to see, but let me just try and see if there are any restrictions anywhere. So you come from a very freedom oriented mindset and then have a look at the restrictions in place. But when we move to capital account transactions, here the situation changes. Here what FEMA says is all capital account transactions are generally restricted unless they are specifically permitted. So see, if any transaction which you are doing gets classified as a capital account transaction, then your mindset has to be, this is going to be restricted. You will have to scout and search for various regulations under FEMA to seek a regulation where a specific permission is given to allow this transaction, only then you can go ahead with it. So the classification between current account and capital account transaction is very important. So whenever in the trust structure we will be ignoring the shelter and we will be seeing the transaction happening between the settlor, beneficiary and the trustee. So you have to first answer a question is whether this particular transaction is a current account transaction or a capital account transaction. Accordingly, your mindset will be either freedom oriented or restriction oriented, and then you go ahead and check which regulations is going to important. So this particular flow is very important, and this like many people regularly miss, but a very important step which you have to keep in mind. Yeah. And then a golden rule of FEMA which has to be kept in mind. What does this golden rule of FEMA say is that whatever is not permitted to be done directly, meaning if you want to do something directly but there is a restriction on it, if yes, then such a transaction cannot even be achieved indirectly. A very, very beautiful rule of FEMA. This is like a substance over form kind of a FEMA or kind of a rule, and the regulator is very clear. See, if we do not want to allow something to you in a direct way, please don't find loopholes in the law and try to do it indirectly. We are not happy with it, so we are making this as a rule that if we come to know that you tried to do something indirectly by evaluating loopholes and the end result of the transaction was something similar to if you would have done directly that transaction and which was prohibited, then we are not happy. Yeah, and they are going to levy a lot of hefty penalties on you for doing that. So you have to always keep in mind that while doing any transaction via the trust structure, you should not achieve any objective which otherwise FEMA was not happy with. Yeah. Now, a very good slide for understanding the gamut of FEMA regulations. Okay, so see, FEMA Act is a very small act. Many a times what happens is that I have seen people and professionals struggling to identify what kind of FEMA regulation you have to go through. So one thing is clear, capital account and current account transaction are defined under FEMA Act. You are able to classify them into current and capital. Then what happens is that you will have to actually see the respective list of regulations, which is a huge list of rules and regulations, and identify what kind of rule and regulation is applicable in your case, and then a study of that is going to let you know whether it is permissible or no. Yeah, so many people try to struggle that, so I thought I'll create a slide for you guys where at least the most commonly used regulations I have listed over here. I've tried to classify them as in what particular topic which regulation is going to be important. Okay, so first is going to be basics and capital and current account transactions identification. Here first of all you will refer to the FEMA Act. Then there are current account transaction rules and there are permissible capital account transaction regulations. Both this will give you at least a starting point to understand whether it is capital or current account transaction. If yes, what kind of preliminary restrictions or permissions are available to you. Yeah, once you go ahead with that, then I said, as I said, that after you have identified the nature of transaction to be current or capital, then you have to see the respective regulation to identify if there is any restriction, especially for current account transaction, or for capital account transaction, whether there is a specific permission or no. So here, typically in the life cycle of trust, you will have settlement, investments which the trustee would make, and the distribution event. So here the most common regulations that you'll have to refer to is the liberalized remittance scheme, because it talks about the gift of money. There are non-debt instrument rules where equity shares are to be invested in, or equity shares are to be settled, mutual funds are to be settled. Basically, financial securities which is non-debt in nature. So you'll have to see to NDI rules. Then you'll have to see debt instrument regulations, which will actually talk about instruments which are debt in nature. And finally, since in cross-border angle, it is possible that even overseas assets could be settled in India trust or an overseas trust. So it is not always inward, there can be outward situation also. So your outward situations would be covered in the overseas investment rules and regulations. Yeah. Even transactions, so most of the family, one of the key wealth which they own is immovable property. So your immovable properties and treatment around that also gets covered in non-debt instruments and the overseas investment rules and regulations. Then comes a very important stage of repatriation. Many people struggle with this also. So there are distributions have happened to the beneficiaries. Now the beneficiaries want to finally take home the money to their country of own residence. So if there is a non-resident who has received distribution in India, would want to take the money back to his home country. If there is an Indian who is named a beneficiary in, say, a trust in Singapore, so he would want to bring the money from Singapore to India. How will this kind of money flow on repatriation happen? That is covered broadly in these regulations. First is the deposit regulations, which gives us information about the different kind of accounts like NRO, NRE, RCNR and different accounts, because that is very important to understand how the repatriation or first remittance would happen to that account, and from that account how will the penultimate repatriation happen. Then there's a very important regulation very commonly missed is for FEMA, realization, repatriation and surrender of foreign exchange regulations. So what happens is that if there is an Indian person, he is owning any asset overseas or he has foreign exchange overseas, then these regulations are important to understand whether you can freely hold them. If not, how, in what time you have to bring that back to India, how you have to convert that into INR, all those information is regulations are mentioned in this regulation, very important to be considered. And finally would be the remittance of asset regulations, which contains the famous 1 million USD scheme. So it's very important for NRIs and OCIs to read this particular regulation to finally see if the distribution that they have received in India, if they want to take it back, then what kind of limits apply to them. So this was about the FEMA regulations. Now we'll not be able to dive more deeper into that, but I'll just cover one important case study which will give you the entire start to end mindset on how you have to approach FEMA. Okay, so say the fact of the case are, there is an Indian resident, he's the settler, his beneficiaries are non-resident kids, he wants to set up a trust in India. Okay. What he wants to do is he wants to settle INR 5 crores into this particular trust. So we have to see whether this particular thing is permitted or no. Okay. So how your analysis will go about is, first and foremost it will be what is the classification of the transaction. So as we had discussed, settlement is akin to gift. So we will be seeing that had the settler directly given this gift of INR 5 crores to the beneficiary, this is how your review of the transaction would happen. So settlement of trust is akin to gift, so you will have gift in mind. Then residential status is extremely important. Settler is a resident, beneficiary is a non-resident. So what are we examining? So we now examine the provisions of FEMA governing gifts from R to NR, because resident settler is giving gift to non-resident beneficiary. So a gift of money is also important, because qua each asset class the gift is the gift provisions change the regulations. So you have to refer different regulations. So here it is gift of money from R to NR. So now you have defined your index. First this was gift, then you decided whether it's from R to NR. and now you are considering the final topic as I have to see or identify regulation that covers gift of money from R2NR. Okay, then you go into the gamut of FEMA regulations and try to decide which particular regulation is important. So before this, over here, gift is a capital account transaction because that is altering the settler's assets per se. Yeah. For the non-resident, so the non-resident beneficiary is getting beneficial interest in an Indian trust. There is an alteration of Indian assets for the non-resident. That is why it's a capital account transaction. Not complicating it much. For now, just bear it in mind that it's a capital account transaction. So now you have to see, for a capital account transaction, you will have to understand that this is prohibited. Now to have a permissibility for this, you will have to specifically scout the respective regulation. So you try and study that a gift of money from R2NR is covered under which regulation. So your answer comes that such gifts falls under the liberalized remittance scheme. Alright. So now you narrow down to LRS, and then you examine whether LRS imposes any restrictions on it or whether it allows this or no. And then you have to finally see whether the trust structure is attempting to override any restriction or no, which is the overarching principle. Yeah, so that is how your flow helps you reach to LRS and gives you a mindset on how you have to read LRS for this. And then finally, for the conclusion part, you understand that LRS monetary limit, so LRS caps the remittances of gift at 2.5 lakh USD per year. But your INR 5 crores when converted to USD is much higher than that per se. Okay, so you are trying to breach the LRS limit. So as per the golden rule of FEMA, if say you would have directly given gift of INR 5 crore to your non-resident relatives, it would have not been permissible. The amount of gift would have been restricted to USD 2.5 lakhs. So now via the trust structure, if you try to settle INR 5 lakhs in the trust, then indirectly you are breaching something which was not permissible, because what happens if this is an irrevocable trust, once the money moves into the trust, then it belongs to the beneficiary. So actually speaking, you have given 5 crores to them in spirit per se. So you have tried to breach something which was not permissible directly. So this is not going to be permissible. So our verdict for this particular transaction is, the clear answer is no, this is not permissible. To do this, you have to take a prior approval from RBI. So whenever in FEMA the answer is no, generally you are allowed to go to RBI, take a prior approval. If RBI is satisfied with the specifics of your case, then they might allow you also. Okay, so you will have to go to RBI for that. Now what happened is that direct gifts are kept up to USD 2.5 lakhs per financial year, which is approximately INR 2 crores. But what you were trying to do is of a transaction which is higher value, which is of INR 5 crores. So this particular transaction was breaching the golden rule of FEMA, and that is why you are not allowed to go ahead with this. So this particular case study will give you a mindset on how you have to traverse the regulations and go ahead. Yeah. Now coming to the income tax part of it. Determination of the residential status of a private family trust. So there is no express guidance available in section 6 of income tax, because trust is not a person, so you don't get any direct guidance over there. Now the implication is very important, because if say your trust is a resident trust, then global income of the trust is taxable in India. But if it's a non-resident trust, then only the Indian income is taxable in India. So the residential status in a cross-border situation is very important to determine the jurisdiction of the country and on what kind of income the country can levy tax. Yeah. Now, how do you determine residential status if it is not given over there? So it's very, very subjective in nature. You have to consider a lot of factors like what is the residential status of settler, what is the residential status of trustee, beneficiary, what is the situs where the trust property is situated. Then you have to see where your trust is getting controlled from, which will be typically the place where the trustee is. So a concept like place of effective management has to be considered. Finally, governing law, which is the law that is predominantly governing your trust and the assets underneath, which is the country where those laws are per se. So holistic factors you have to see. Now, no single case would have one single answer. It has to be very, very fact specific, and you have to drive deep into the subjective part of it. And then a combined reading of multiple factors is going to arrive at a conclusion and what is your residential status to be. Right? So please remember, do not consider any single factor in silos. Always have a combination of factors, because if you only consider single factor, high chances you might go wrong or an aggressive position on the tax front. And one very strong suggestion from my side is, when you are drafting the trust deed, at that moment, whatever is the position of your assets and the key constituents, do an analysis of the residential status and mention a clause as part of the trust deed that, based on the dynamics and facts that are at present today, our analysis is so and so, and based on this analysis we feel the residential status of the trust is going to be resident in India. Please add this as part of your trust deed. What happens is, if you add this as part of your trust deed is, if in future any litigation arises or any question comes up per se for specifically the cross-border situations, then if something would have already been part of the trust deed, it will at least help you prove before the authorities that we are not making up things. It is not when you have sent us the notices that we are taking this stand. All throughout our thinking was the same. Plus, this trust deed was also submitted to you while taking the PAN in India. We have been all throughout submitting the trust deed to all the regulators. So there was no intention to hide anything. This was always our analysis, and that is why we had made that as part of the trust deed. If there is any complex situation where it's a very complex trust structure, a good possibility can be, take a opinion from a consultant, tell them to determine the residential status quo that particular date, make this opinion as an annexure to the trust deed, part and parcel of the trust deed. So these kind of things would increase the merit of your residential status, and it might help you save on the penalty front if, say for example, later on it turns out the tax officer did not agree with your conclusion of the residential status. Yeah. Now our last slide, which talks about the cross-border tax challenges that the trust face. First is a very important issue of hybrid mismatch. What happens is that the classification of a trust structure qua each country can be different. Some country can consider that as a transparent structure and the beneficiaries have to pay tax, whereas some country might consider that to be an opaque structure wherein the trustee at the trustee level has to pay tax. So there can be mismatch between two countries, and then it can lead to certain issues. Another can be mismatched timings for taxability. Like say certain countries can tax in the hands of the trustee on accrual basis. Some might say that no, the corpus has to keep on growing. Whenever the distribution would happen, penultimate the beneficiaries would pay the tax on distribution. So there could be timing difference between taxability, again which would create a lot of challenges in a cross-border setup. What kind of practical challenges you will face is, first is definitely determination of residential status. Maybe your analysis in India says it's resident of India. Some countries, authority or consultant would say you are resident of that country. So at a point of time, there could be like a tie-breaking situation where you end up being resident of more than one country. Such kind of complications can arise. Then it is going to be difficulty in claiming of foreign tax credit. So all these mismatches, hybrid mismatches, the predominant issue is that it creates a lot of issues while you are claiming the foreign tax credit. Finally, the UBO disclosures. So the trust structures, they lack a kind of transparency and uniformity in terms of disclosures that you have to make, especially where structures are like discretionary structures. There is a lot of ambiguity between multiple countries' law on how disclosure should happen. So this also affects your exchange of information part, and it creates unwanted inquiries and notices from the department. So these are certain tax challenges that you will face in the cross-border setup. So yeah, I think with this, we have finally ended our entire 7-day webinar series. I'm really grateful to all of you because, without our audience, it would have been impossible to reach so far. Yesterday only we were discussing in the team that we have almost 3.5 hours of, content, which is we have recorded over this 7 days. Only for my speech. Q&A part is different. And so it has been an excellent journey, and we were also just checking that if such a kind of an extensive knowledge pool, if it at any point of time is available in free public domain, so we couldn't find that. So we are happy that we are able to contribute to the fraternity by creating such a good knowledge base, and we'll always be keeping this open to public with absolutely no charge, because we believe in copyleft. Knowledge should never be copyrighted. It should always be available to general public at large. per se. So really grateful for the entire efforts, and I would specially like to thank each of my team members, Beenal, Ami, Smith, and Dhruv Raj. Without their contribution to put such an extensive series in place and to execute it in such a smooth manner was impossible, at least for me to do. I would completely say that my contribution is the least in this entire webinar. It is this team who has created this entire framework, content, and everything, due to which we could reach at such a smooth level towards the exit. So today being the last day, I would just like to invite one of my team member, Amisha, who is a chartered accountant who helped a lot in the taxation segment of the part, to just share her views in about a minute or so, and then we may move on to the Q&A part, because without our team having receive any screen time and to share their views, I wouldn't have done the right justice to them. So yeah, over to you, Ami. Yeah.
Thank you, DS. Good evening, everyone. I'm CA Amisha. I would like to briefly share a few thoughts from our side. So, while working on the preparation of this webinar, our team had the opportunity to go deeper into various aspects, such as structuring, legal consideration, tax implication involved in succession planning. So, during the preparation process, we also realized how important it is for families to start succession planning early and align legal, tax, and governance structures in a well thought out manner. So we would also like to thank all the participants for their active engagement and insightful questions throughout the sections. Your questions and interactions help deepen everyone's understanding and turning this webinar into a two-way knowledge exchange. So thank you, everyone. We hope that the discussion during these sessions have been useful and will help participants approach succession planning in a more structured and informed manner. So thank you, everyone.
Great. Thanks a lot, Ami, for sharing your views. Yeah. All right, guys.
Thank
So
you.
now, yes,